Assalamualaikum and good day. I wish to my respective lecturer, Dr. Ratna, and my fellow classmates. I am Nur Iradat Binti Zulkifli. Together with my group partner, Grace Naomi, will talk about the topic under international law, which is sovereignty and jurisdiction. So let's have a look on what the definition of sovereignty and jurisdiction itself before we go further. Sovereign, in a simple words, we can say that sovereign is the power or authority to rule. But to make it clearer, sovereign is where every state has its own power or rights to govern its territory without the outside intervention. Jurisdiction is where the state have the power to govern its own people, territory, and situation. So there are three types of jurisdiction. First is legislative. Legislative is the power to enact legislation or establish laws that will apply to all people, property, territory, or events within its limits. Or legislative, also known as the supremacy of the constitutionally recognized organ of the state to make binding laws within its territory. But the state can extend this jurisdiction to persons, property, and events that taking place outside their territory. Okay, next, we go to executive. Executive is the capacity of the state to act within the border of the state. So actually, from what I understood about this matter, state is actually share the power to enforce the law to certain body like the police and army. Actually, the state formally cannot enforce the law without the attribution of conduct to a state. The executive are the one who have the power to enforce the law that has been bind and can take action towards the people who breach the law. As we go to judicial. Judicial or adjudicative is the power to hear and settle legal disputes. This happen in the court. Judiciary is the one who is responsible in this jurisdiction, where the judge have the right to hear and sentence all the disputes that has been brought to be tried in the court. So next, let's have a look on civil jurisdiction is where civil law deals with conflicts between individuals or between persons and another private body, such as a corporation or organization. In a civil dispute, one side commonly claims that the other party committed a crime or was negligent, resulting in loss or harm. As we go to criminal jurisdiction. Criminal law is a body of legislation that deals with offences committed against the government or society. Even if the victim is an individual rather than society as a whole, in case of murder or assault, conduct may still be regarded a criminal case if it contains unlawful behavior. Criminal law seeks to punish criminals rather than to settle conflicts between individuals. 5 principles under criminal jurisdiction. They are territorial, nationality, universal, passive personality, and protective principles. We go to at territorial principle. Okay, territorial basis for exercising jurisdiction presents one part of a state sovereignty exercisable in territorial territory is the necessary foundation for the implementation of a state's set of legal rights. So, territorial basically is the ability of a country to legislate regarding activities on its territory and prosecute for crimes committed on its soil is a logical manifestation of a world order of independent states and is entirely understandable given that the authorities of a state are responsible for the administration of the law and the maintenance of good order within that state. We go to protective principle. Okay, this concept asserts that states may exercise jurisdiction over immigrants who have committed an act abroad that is regarded detrimental to the security of the state in question. The state can claim jurisdiction over offences committed outside territory which are considered injurious to its security or vital economic interests, open to danger of abuse. How to get nationality? So there are four ways to get the nationality. So there are jus sanguinis, dually, marriage, and also by naturalization. In general, the two most important principles upon which nationality is founded in states are first by descent from parents who are nationals, that is jus sanguinis, and second by virtue of being born within the territory of the state, usually. Commonly accepted that a child born of nationals of a particular state should be granted the nationality of that state by reason of descent. The common law countries have tended to adopt the jus soli rule, whereby any child born within the territorial limits of the state automatically becomes a national thereof. Let's have a look at the nationality from marriage. Nationality may also be acquired by the wives of nationals. In the Convention of 1957 on the nationality of married women provides that contracting states accept that the marriage of one of their nationals to an alien shall not automatically affect the wife's nationality, although a wife may acquire her husband's nationality by special procedures should she so wish. Last but not least, nationality also can be obtained by an alien by virtue of a naturalization process, usually involving a minimum period of residence. But the conditions under which this takes place vary considerably from country to country. Next, passive personality principle. The passive personality principle recognizes that a sovereign can adopt laws that apply to conduct of foreign nationals who commit crimes against the sovereign's nationals while the sovereign's nationals are outside of the sovereign's territory. Under this principle, a state may assert jurisdiction to trial a person for crimes committed abroad that have impacted or may affect its nationals. Last but not least, the universal principle. Universal principle. According to this principle, each state has the authority to trial specific offences. The reason for this is that the offences in question are particularly repugnant to the world community as a whole. There are two categories that clearly belong to the sphere of universal jurisdiction, which has been defined as a state's competence to prosecute alleged offenders and punish them if convicted. Regardless of the location of the crime and regardless of any link of active or passive nationality or other grounds of jurisdiction recognized by international law. That's all from me, and I will pass my this presentation to my partner, Grace. Thank you.
Thank you, Ili. I will proceed to give more explanations using Lockerbie case and Lotus case. On December 21st, 1988, a bomb exploded in the cargo hold of Pan Am Flight 103, killing all 259 passengers and crew, as well as 11 residents of the town of Lockerbie, where the wreckage of the Boeing 747 crashed 31,000 feet below. After years of negotiations and diplomatic maneuvering, in April 1999, Libya surrendered the two Libyan officials accused of the bombing, Abdel Basset Ali Ahmed Al-Mehrani and Ali Amin Khalifa Fima, for trial. In this case, the principle that applies is territorial jurisdiction. To decide which court of a country should take this case, they agreed to give the court to Scotland. The reason for this is due to the evidence was located in Scotland territory. It is easier to examine all the evidence and under a court of Scotland. For the United States, it supplies nationality jurisdiction because 190 Americans were in that plane. Like what my friend said, this principle applied to every citizen of a country, either in home country or overseas. Lotus case concerned a criminal trial which was the result of 2 August 1926 collisions between the SS Lotus, a French ship, and the SS Bozkurt, a Turkish ship, in a region just north of Mytilene, Greece. As a result of the accidents, 8 Turkish nationals aboard the Bozkurt drowned, where the vessel was torn apart by the Lotus. The issue at stake was Turkey jurisdiction to try Monsieur Demons, the French lieutenant on watch duty at the times of collisions. Since the collision occurred on the high seas, France claimed that the state whose flag the vessel flew had exclusive jurisdiction of the matter. France proffered case law, through which it attempted to show at least state practice in support of its positions. However, those cases involve ships that both flew the flag on the same state. The court therefore, by a bare majority, rejected France's position, stating that there was no rule to evac in international law.